Hi, welcome to Cutler Legal Basic Law. Today we're going to talk about complaints. First question is, what is a complaint? A complaint is a document that sets forth the facts underlying your lawsuit as well as the causes of action or the legal claims that are the basis of your lawsuit. First question is, what must I include in my complaint? You need to have the name of the parties, a description of the facts giving rise to the complaint, as well as a identification of the legal wrongs. Today I've brought in a complaint that I did in federal court, and you can see here at the top I've listed the parties, the plaintiffs, defendants, the court. It's in the United States District Court of Massachusetts. In this situation I had the case number, and this was an amended complaint, so you do have an opportunity throughout the lawsuit to add and refine your complaint. This was a third amended complaint, and the first page you see is I have the preparatory allegations. That's a description of the parties and who they are. Then in federal court you have to say why the court has jurisdiction, why that federal court is a proper federal court versus maybe a federal court in Minnesota. And then I go on to the background, and here I provide a description of the facts. They go on for quite a few pages. And then we get to the causes of action. In this case, the first cause of action is for fraud and intentional misrepresentation, and those are the legal elements of that cause of action. And then at the end, we have what we call the prayer, which is a description of generally of the relief we're seeking. It doesn't have to be specific, it's just a general, whether you're seeking attorney's fees, treble damages, you're seeking injunctive relief, you're seeking an order from the court. And finally, you should put in a request for a jury. You don't want to waive that. Even if you don't want a jury at trial, you get to that stage, put it in. You can always waive it at the end, but you don't want to waive it beforehand and lose the chance to have a jury. Do I need to put in every fact? No. You don't want to hem yourself in. You don't want to put in every fact that then comes back and haunts you. Two, you want to present a logical story. And sometimes fewer facts are better. Even though a fact may be relevant, it dilutes the other facts. So pick your key facts, pick the facts that are logically connected, and put those facts in. You're not trying your case in the complaint. You are simply giving the court and the other side a roadmap of generally where you're going, what is the general circumstances giving rise to your complaint. Conversely, you don't put in as few facts as possible. The judge is going to pick up this complaint throughout the case. You do a motion or something comes up, and they'll read it to understand what it's about. You want them to read it and have a good understanding of your suit. That also means don't get emotional in this. Try to sound objective. Even though you're not objective, try to sound objective. So that when the judge reads it, they go, oh yeah, this person's being reasonable. They're objective. It's logical. I understand. There is something here. Okay. Once you finish writing the complaint, you need to file it with the court. And when you file it with the court, that's when you get the case number. And I showed you that at the beginning. And in this case, this was the civil action number. And from then on, everything you file with the court, pleadings, motions, anything that goes to the court shall have that number on it. You also need to get from the court a summons. And here's the summons that went with this case. And when you go to serve your complaint, you also must serve a summons. It's a legal order for the party to appear. So you'll get a blank summons, and you will have to fill it in describing the parties, etc. It's quite easy. There are not a lot of lines to fill in. Okay. When you're drafting the complaint, please look at your local rules. Every jurisdiction has different rules. For example, California requires your pleading papers to have numbers along the side. Other jurisdictions don't. So take a quick look at the local rules just to make sure it's formatted. But the general formatting is very similar to what I just showed you here, with each state maybe having a variation from that. Okay, then when you have the complaint filed, you have your summons, then you need to serve it. And normally you use a sheriff or a constable. You have to pay them, $20, $40. They will go to the home of the person that you're suing, or if it's a business, they'll go to the business and they'll drop it off. There's specific rules on what constitutes good service. The constables have a good understanding of that. Again, unfortunately, it's one of the more, I wouldn't say terribly tricky, but somewhat tricky areas. Take a look at the rules. They're online as to what you need to do to complete service, but serve the complaint. Once you serve the complaint, then the defendant has 20 to 30 days, depending on the jurisdiction, in which to answer. That means they have to go through, and particularly in federal court, you see how each of these facts are numbered. Every paragraph is numbered. Yes, numbered. They have to go through and either admit or deny each of those paragraphs, or state they have insufficient information to admit or deny. And if you're answering, you have to do the same thing. And if you cannot admit or deny because of insufficient information, please remember to deny it. So say I have insufficient information to admit or deny that claim. As such, I deny it. Because if you don't deny it in federal court, the court can treat a non-denial as admission to that fact. And again, you don't want that to come back and haunt you during the case. All right. Now, what happens if the complaint's not answered within 20 to 30 days? Let's say you get the complaint and you don't answer it. Well, the plaintiff can go to file a request for default after the time has expired and request that the court enter your default. Meaning, at that point, you cannot answer the complaint, and you're going to have to go to the court and ask the court to lift that default. And if you don't ask the court to lift that default, then the court will set a hearing to prove up damages, at which point the plaintiff will go to court and present evidence of what their damages are, and then the court can enter a judgment on the complaint and award damages, and that's the conclusion of the case. A very bad result. So always remember, it's important to answer those complaints. Also, when you serve the complaint, you will get back from the sheriff a proof of service showing that the sheriff had served the complaint, or if you use a private process server, that they served the complaint. That needs to be filed with the court, so there's record with the court that the complaint has been served. They're going to need that to enter the default. And you have a certain amount of time in each jurisdiction in which to serve your complaint. And if you don't serve it with that amount of time, the court can start moving toward dismissing your complaint for failure to prosecute, i.e. failure to take action, failure to do anything. You can't just file a complaint and sit on it. The court wants you to serve it, wants to process it, wants it out of there. Doesn't want people just filing complaints and not doing anything with them. So, I hope that made some sense. That is basically what a complaint is. Thank you.